Good morning, everybody. My name's Andy Bates. I'm an innovation manager and the intellectual property lead here at Business West. And a very warm welcome to everybody on this autumn day, and welcome to our autumn webinar and thought leadership series, Innovate 2021, Overcoming Challenges and Building for Growth, which is supported by Business West and Innovate UK. This series of webinars is running every Tuesday morning throughout the autumn, covering topics from design thinking, funding and finance, leadership and strategy, sales and marketing, as well as promoting the wider bespoke support available from us and how we can add value to your future growth plans in what is a very challenging environment for all of us. Kicking off the programme is our four-part series on intellectual property, being delivered in partnership with our colleagues at Ingot. And I'm delighted this morning to introduce Dr. Alison Orr from Ingot, who will be our host for this session titled IP Valuation for Collaboration, Seeing the Value of Your Own Contribution. As well as Alison this morning, we'll also be joined by Ingot co-founder and CEO, Martin Brassel. So good morning to you, Martin. And as a participant of Innovate 2021 and subject to Innovate UK eligibility criteria, there is the opportunity to access our comprehensive range of intellectual property support, including advice from our in-house patent and trademark attorneys, access free of charge to our online IP evaluation tool, which typically costs £600, and in some cases, access to a £2,500 subsidy towards the cost of an intellectual property audit from one of our external IP or from an external IP attorney. Again, all subject to Innovate UK and Intellectual Property Office eligibility criteria. But I can discuss all that and how to access those services at the end of this session. Now, before I hand you over to Alison, there's just a couple of housekeeping bits that I'd just like to walk through with you. So to start with, for on-demand purposes, this webinar is being recorded, and also your video and phones will not be used unless you're invited to speak by the host. We've also got a Q&A section as well within Zoom, where you can ask a question either in person or anonymously, and this is being moderated. So please can you put your questions into the Q&A section, because that is being monitored by us. If you've got any problems or anything like that, please raise your hand and one of the team will come to your assistance. And also there is a chat function as well for you to communicate with other attendees. This isn't moderated. So again, if you're going to ask a question to the panel, please can you make sure that you put that into the Q&A section. Presentation wise is that there will be a more detailed reference copy of the slides that will be sent to you post webinar. So without further ado, I would like to hand it over to Alison. Alison, it's over to you to start the session.
Lovely. Good morning, everybody. First of all, I've asked Andy, can you hear me okay? Thumbs up perhaps, and see the screen. Yeah, great, lovely. Thank you very much.
Great. Thanks,
That's absolutely fantastic. Well, thank you, everybody. It's nice to be here this morning. As Andy's explained, I'm Alison Orr and I work for Ingot Limited, and I'll be the main presenter today for the Ingot team. To give you a little bit background to me, I work for Ingot for about 7 years now and routinely help companies to value their IP for different purposes, using both the Ingot online tools that Andy's mentioned and also our bespoke services. And I also deliver a lot of IP audits. So as part of those audits, we also do and advise companies how to manage their IP in a collaboration, which is the topic today. Prior to joining Ingot, I worked for a firm of patent and trademark attorneys. I worked in private practice for a number of years and also worked for this wonderful EEN network for 10 years. So it's great to be back and supporting the work that they're doing. So I can really vouch for how powerful a network it is, and I hope you can engage with the EEN team at Business West. For today's session, we've got a bit of a double act, so you don't need to listen to my dulcet tones for the whole session, but my colleague Martin Brassel, our CEO, will be speaking a little bit later, and we'll introduce him and he'll take you through to the Q&A. So without further ado, hopefully we can move on. If I can get my slides to work, there we go, that's us. So what we'll be presenting today, this morning we hope to consolidate the learning on IP valuation from the previous 2 webinars, including IP valuation in licensing. However, don't worry if you weren't at those webinars. If you're joining us for the first time today, all the webinar recordings and slides will be available to refer back to. So that's great news. So it is a big topic and we've crammed it into a short period of time, but I hope obviously the recordings and the slides will be useful to come back to. So the last webinar was on licensing, and licensing is in fact a formalised collaboration in itself. So it has relevance this morning, but other types of collaborations include consortium agreements, often found in grant-funded activities, so the type of Innovate UK grants perhaps that you will be hearing about, no doubt, in the future from the Business West and EN team, and obviously other things like franchises, manufacturing agreements or subcontracting agreements, so all important to understand what to do in collaborations. But today we'll mostly focus on consortium agreements and grant funded activity. So we'll shortly set out the benefits of the collaborations, what we mean by IP in the context of collaborations, set out some risks and how to mitigate those risks by IP management tips, and also just how to bring in IP valuation and where it's important in terms of really maximising the value of your IP within these collaborations. Obviously it's important to manage your IP well to be able to do that. So we'll also introduce you, as Andy's mentioned, to an offer via host today, part of EN and Innovate UK, which will allow you access to INGOT's clever online IP valuation tools, which I hope will benefit your business or your clients in the future. You know, we're in an increasingly intangible-led world, so if you manage what you're doing well with your IP, hopefully you can exploit those fully and monetize them. So why collaborate? In short, it's as simple as you might need to collaborate with other companies and or research institutions to create new IP. It might be that you don't have the expertise or physical or financial resources to develop all of the IP your business needs in-house. Or it might just be quicker and more cost effective to collaborate with partners. You know, there's no point in reinventing the wheel perhaps if someone else has done that, and there might be a way of getting it to market quicker. I mean, a good example of this actually when I worked in the EN team, and you know, we work with companies all the time in INGOT as well. You know, just thinking back to a little probiotic company that was working with, and they were developing quite a number of novel sort of probiotic strains, but they needed a way of actually getting it to the human gut. You know, historically it was always in a sort of drink formula and it wasn't actually getting to your tummies and things appropriately. So I actually introduced them to a drug delivery company that had this sort of drug delivery means to get those probiotics to the gut. So that turned out to be a really lovely collaboration, and they worked together for many years, and they actually got this product to the market. It was one of the first probiotic encapsulated products to make it to the market. So it was a win-win for both sides. It was non-competitive, but you know, there was different forms of IP coming together. So some opportunities for collaboration, certainly the first one, it's an outlet for your company to innovate. For example, you could acquire rights from others that can help your business to innovate more quickly, you know, compared to developing everything in-house. And likewise, you can grant rights yourself to organisations out with your business. You know, it could be other industries or fields that can also help your business to be more innovative. Collaboration can also help you to internationalise. A great way of engaging with the EEN, they can help you with this. You can help as a business, you can be granting rights to organisations that already have contact and distribution networks in other countries, and this could be a lot quicker and more effective for you than if you had to do that yourself by setting up all your own direct sales operations in country. And it can also help you to improve revenues and profitability. So that's a key one. You know, for example, you can grant rights to your IP to a collaborating partner, which provides a chance to create new IP and collaborative R&D or new revenue streams for licensing or selling your IP at home or abroad via partners. So you might wish to acquire IP rights yourself, and this is a form of technology transfer, a flow of these intangible assets. So it can be know-how and patent information, for example. And there's been quite a number of studies over the years to actually show, how working and collaborating can actually help you. So by working internationally, for example, often this can lead to new IP in itself, with over 50% of UK firms in a Department of International Trade study, of those exporting, they have evidence of bringing new products or services into the markets. It might be something as simple as identifying through an international collaborator a new type of IP that's not available in the UK, and you could end up having exclusive rights to commercialise that. So a very brief overview of what these IP assets look like in a typical collaboration. So it can be your typical registered rights, so things like patents, trademarks, or designs. In a technical collaboration, often it might be patented innovations, and these sort of R&D type collaborations, that's really important. It might be a process or a material that's intended to be developed as part of the collaboration to develop new IP, and using such new IP for new markets or uses or applications. However, use of registered rights can also be actually quite a lot less techy. It's just as important to perhaps collaborate and get access to trademarks, for example. In particular, it might be manufacturing or subcontracting arrangements, or obviously some sort of a franchise. So that would be access to branded goods, the use of the brand. In a food and drink franchise, we know about McDonald's, Costa Coffee, these types of things. The correct use of the brand is really imperative, and the attention to detail to use of that brand, and also use of other unregistered IP rights, such as recipes, for example, will be really important to ensure that you maintain the goodwill of your customer and the trust of your customer. However, it's not all about registered rights. There's obviously a lot of other intangibles in there. So one of the main ones is copyright. As you can see, that can be things like creative works, software, manufacturing specifications, maybe recipes. As I mentioned earlier, in food and drink, if the recipes are not used appropriately by a franchisee, you might actually get a lower quality product. And this can lose customer trust and goodwill, but it's super important. And obviously, if you manage all of these things well, then the value of your IP will increase. There's also contracts. As you can see, there's different types of contracts involved in a collaboration. It may be something like a grant agreement. A grant agreement is something that's a standard contract that you will have with the grant body that obviously sets out what you can and can't do during that particular grant funded initiative. There's also going to be a collaboration agreement probably as well. So that's more the agreement between the partners, and I'll come on to that in terms of what you should and shouldn't do with those. So setting out IP management and exploitation rights, it can also extend to consultancy agreements and also IP licenses. We've also got resources. Now, resources are internal company controlled assets that are integral to your company's offer, and this can extend to know-how. So know-how is definitely going to be needed for collaborations, telling someone how they might be able to use your IP in the correct way. And that know-how will be defined if you're bringing it to the table as background IP, and I'll come on to that sort of definition in a little bit more detail in a second. Finally, we've got things like relationships are also important, another form of unregistered IPs and intangible assets, still important. External non-contractual connections, these could be customer lists or market knowledge, and could be useful at the end of your project to help with exploitation opportunities. And finally, we've got recommendations. It could be independent external evidence or approvals required for your market. It might be a quality standard, for example. All of these things have value. They're all intangible assets. You might not be able to touch or feel them, but they've got value, and you have to obviously manage them well to maintain that value and hopefully increase that value. So we'll have hopefully some top tips in terms of how you go about doing that. So in a typical collaboration, you will start to hear of terms called the likes of background IP. These are typical terms in a collaboration agreement. Background IP, simply put, is IP that's probably owned by one of the collaborators that's existed before the project has started, or it's generated outside of the project. It's probably going to be pretty essential for the project, and you might need to provide access to that background IP to the other project collaborators. The background IP could be made up with any of or all of the issues and the IP rights that I showed on the previous slide. It could be obviously registered rights or copyrights, patent applications that have been filed prior to the collaboration, things like prototypes, cell lines, database rights, licenses, all of those things. But what's really, really key if you ever get into a collaboration is to ring fence that background IP. In my words, you wouldn't want to get into a bun fight at the end of the project collaboration in terms of who actually designed what or who created what, and you want to ensure that your background IP is very clear. And normally all you do is you define that in writing in a collaboration agreement, often as an appendix. So it can also be important to get that background IP valued, and Martin will share details of that and why and when it's important to do that as well. The other term that you'll hear a lot of is foreground IP. So again, simply put, that's the things that you're actually creating as part of your collaboration. So IP that arises from the project. It will be hopefully that IP you're going to be generating and exploiting. And again, in your grant application, setting out what that foreground IP is expected to be, and possibly the value to the market of that will be important in terms of whether you actually have a successful application or not. You know, often these are competitive grants. It's really important to get that set out right. And again, avoiding the bun fight at the end of the project, ensuring that you set out who is going to have exploitation rights, and that there's obviously things that you can do as well. I'll come on to that in a second. And sideground IP, just another term to be aware of. It's normally IP that's generated maybe during the term of the project, but it's really not got anything to do with it specifically. But it's important to have it in writing, you know, in your collaboration. A partner can't use any sideground IP that's not set out in the project aims and objectives without permission in writing from you. So there's lots of positives in collaborations, but there are obviously some risks that you should take into consideration. One of the things that you might want to consider is the fact that literally, as you can see on the table here, we've got different people, we've got different organisations. You might have an academic, a government agency, you might have a multinational, an SME, different mindsets. So you want to ensure that those personalities as well are obviously managed well, and it's really important to choose your collaborators wisely, because and do your due diligence and pick them wisely, because they all come to the table with different mindsets. So do your due diligence on your partners. You know, it might be possible, for example, using research to actually see if they're actually active in mergers and acquisitions, for example. Are they entering into collaboration with the right reasons? You know, it has to be, you have to be working together, obviously, on all these issues to an end goal, and, you know, that will benefit everybody. Academics, no disrespect to any academics on the call, but you obviously have different motivations, and, you know, you'll be pushed internally perhaps to publish more, and one of the things that you would need to consider is that a partner, an academic in particular, might want to publish the results of your collaboration early. There should be things in your collaboration agreement to ensure that they don't do that, or at least they give you notice they're going to do it, so you've got the opportunity to actually ensure that you can apply for patent protection, because if a disclosure is made, you could invalidate your future right to any patent protection for that. Multinationals might want to sign NDAs or may not want to sign NDAs, and they'll obviously have different, you know, they'll be driven to exploit the IP, and, you know, they want to ensure exclusive rights. So again, it's important to understand these things. There also might be slight differences in international laws. So again, around IP ownership. So it could be that maybe if an undergraduate on the academic side is involved, it might be that the university doesn't actually own the academics, the undergraduate's outputs. Under the law, it's a little bit different in different countries. Sweden in particular is a different one. So you need to be aware of those differences in international law and get it written in, because it leads on to the super important part about collaborations, is getting the ownership sorted as early as possible. You need to agree who owns what in terms of at the outset, who's going to own what you generate and who's going to have the exploitation rights, just to avoid those sort of future disputes. So you want to set out the background IP, you want to avoid joint ownership if possible. The main reason for that is it just makes it a lot cleaner down the line. So joint ownership, if at all possible, should be avoided. Simply, it might be that, you know, during patent prosecution, you might have one owner. That person is the key point for your patent attorney. They're the ones that obviously have to sign documents. And if you're having to chase around for lots of different partners to get documents signed, it can get really messy. And so having one applicant, one owner, and then having licenses in place to obviously get access to that IP down the line is obviously important. The timing of the agreements is super important. Get it done at the outset, and obviously, you know, try not leave it too late, really, so you can get the clarity on the ownership and the exploitation rights as early as possible. And really just ensure you don't undervalue your IP. You know, as I say, background IP is important to identify. You can utilise the Ingot Goldstein profiling tool for that, for example, and also it's also important to value it on occasion, and Martin will talk about this in a few minutes. I've used this example in terms of dealing with IP and grant-funded applications. Now, this is Horizon 2020, it's coming to an end, but it's just as, you know, it's relevant, as I say, for lots of different reasons. You know, it could be equally as applicable to Innovate UK, for example. And it's, as you'll see when you're applying for these sort of competitive grants, the grant body wants to see impact, and this can relate to you know, the valuations relating to the IP as it concerns the development, dissemination and use of the results. That's the foreground IP. So you must set out these sort of plans for dissemination that involves your IP, and it's equally important to obviously show how you're going to exploit it and get all of those rights, as I say, with your partners in place as early as possible. For example, in terms of IP and how you're pulling your application together right at the beginning to help you to show how it's innovative and, you know, show that it's different, and obviously place a value against it, perhaps, that can help you with your application. You can use your patent and trademark databases to actually show how things are different, and how, what you're going to produce is going to be different to anything that's on the market. And as I say, setting out a value at this point as well for your application, and having an IP valuation to show the sort of future opportunity and value, as it can also be useful. And as obviously as well, what the grant body wants to see is actually how you're going to manage that. There might be costs available to help with your IP protection costs, you know, patent protection applications, but also the exploitation side of things as well. So that's a sort of generalisation of how these sort of grant funded applications look like. You know, there's going to be differences and different types of grant bodies, and it's really important to ensure you're aware of those, and obviously choose the grants wisely also, because you may or may not be able to negotiate the terms in those going forward. So that's certainly some of the key matters. So just some final points. I've talked quite a lot about collaboration, and you'll have a chance to refer back to these slides after it, but in collaborations, as a reminder, really important to choose the collaboration partners carefully. As I say, different mindsets coming to the table, multinationals, SME, academics, all with different needs and wants. So do your due diligence on those. And use the legal agreements property. Understand the difference between a grant agreement and a collaboration agreement, for example. So the grant agreement is with the grant body, and they could be very specific, and the terms might not be appropriate for you at the time. So you need to consider those. And obviously the collaboration agreements are the ones that are a little bit more, ones that can be driven by you. So it's working with your collaborators and ensuring you have all of the terms and conditions in place that are going to be important to you. So it could be, you know, how you deal with risks, if somebody runs out of money, if somebody wants to publish early, all of these things. So it's maintaining confidentiality and ensuring that they're using your IP appropriately. So really important to get all of those documents in place early. If you can, try and avoid shared ownership, as I've mentioned. You know, joint ownership is just, it can be messy. And just be very, very clear on ownership generally going forward. So just some top tips to keep in mind. And as I say, on the slide set that will be shared afterwards, we provide a little bit more detail on these. Also for some further help, there's some really nice online guides available that you can access also through the EEN team. Andy and his colleagues, but one of them is called the Lambert Agreements, that within a Lambert Toolkit that was produced on behalf of the UK Intellectual Property Office. Some great model agreements just to help set you through what to do in a collaboration. And there are also some really lovely other free resources from our friends at the European Commission. So there's something called the EU IP Help Desk. The one for the EU is in particular, I've got some really neat little guides in terms of IP and collaboration. Some of them were drafted originally for Horizon 2020, but as I say, they're going to be applicable to other types of grant, and obviously they'll be refreshing those for Horizon Europe next year. So I've realised I've just clicked straight on to the next side of slides. So you can stop listening to myself, and I'm going to pass it over to my colleague Martin. I'm going to be in charge of the slides, so hopefully I can keep up with that. Okay, thanks.
Thank you very much, Alison. Yes, good morning, everybody. So let's now focus on these elements that are very specific about valuation. And I thought the best way to start is to say, when would you start thinking about intellectual property value? By which we mean IP in the broadest sense, as Alison set out earlier on in the presentation. Well, there are some things that are quite useful to start thinking about even before you start the collaborative work, the collaborative project. Having some kind of a sense when you're going into the negotiations about who should do what and who will own what at the end of it. It's pretty helpful to have some concept of what the background IP that you're contributing, as opposed to other people are contributing, is worth already. And sometimes you'll find within certain types of grant application that there's also a particular focus on what you're going to be creating and routes to market for it. And if you have to start thinking about routes to market for these things, then that means you're also going to have some kind of an idea of what you expect the financial returns to be. And if you've got that, then you can also start thinking about the value of the new IP that you're expecting to create, which is always a useful thing to be able to include within an application. So there's a few things before you start. Then under the next heading, we think about what might prompt you to consider IP value while you're in the process of collaborating. One of the things that may transpire is that a business case starts to surface for either creating a new venture or some kind of a joint venture in order to commercialize the IP and bring it to market. And everybody's got to start thinking at that point about what the value is that they are putting into it. What will the total value be of the IP that will be vested in any joint venture, and who's actually contributing it? So therefore, who should own what proportion of the joint venture company? And even if you don't go down the route of creating a joint venture, you might still need to do some fundraising in order to commercialize the outputs of the collaborative research work that you've done. And sometimes it's quite helpful to work these things out before you know exactly what the final outputs are, because that can rather change the dynamic sometimes on the negotiations. So that's before and while. What about after? Well, after, One of the things that you might conclude is that something needs to be done about ongoing access to that big circle called background IP, which Alison talked about earlier. And that might be your background IP, or it might be somebody else's. Usually within most of the collaborative agreements that I've seen, during the course of the actual project, you have a free license to be able to use the other collaborators' background IP, but only for the purposes of completing the project itself. If there's an ongoing dependency on background IP, then that is going to have to be compensated for in some way, quite possibly financially, unless there's some kind of cross-licensing arrangement because actually everybody contributes an equal amount. But in any event, you need a basis for thinking about that. And the usual way of doing that would be to agree some kind of a royalty arrangement following exploitation. What is that royalty amount is the question that then comes onto the front of people's minds. And that's the kind of thing that you can discover in a valuation process. And that can apply regardless of whether you're the person who is exploiting the technology and therefore having to think about how much royalty you need to pay other people, or it can apply if somebody else is doing it and you want to get paid on a royalty basis for the IP that you're allowing to be used. Last thought is sometimes the IP might actually not be in the right place. So rather than pay a royalty for it, it may be better to simply transfer it either between companies or sometimes between operating units of the same company. So under those circumstances, you have to think about what the value is for its transfer, which is something that also requires IP valuation and which can also generate a tax liability. So there's a few things to think about there. Thanks, Alison. In terms of the methods that you might use, so just to act as a quick refresher for anybody who wasn't on the previous session, there's three main ways in which you think about IP valuation, and I'll talk about their suitability in just a moment, but just to present them to you first. Cost is method one, which is really asking one of two possible questions. One is, how much would it cost somebody else to reproduce the assets that you've got? So in other words, to start all over again from scratch, but do exactly the same thing. And the second question is, how much would it cost to replace a given set of assets with something that does the same thing, but does it potentially in quite a different way? So that's not a reproduction, that's, if you like, a direct replacement. The second method that you can think about is market comparisons. And of course, this is the way that we tend to value pretty much all tangible, hard physical assets. We think about a price for them in the open market. You can think of property, you can think of cars, machinery, almost any of these things. So the first question that you might try to ask is, have comparable sets of assets to the ones that you've identified been actually sold on the open market? Now, usually the answer to that is no, they haven't, or if they have, we can't tell because it's been done under confidential conditions. So that doesn't mean all forms of market comparison are impossible, but it means you have to start thinking about proxies, if you like, for what that value might be. So when we're approaching these things in our bespoke reports, we tend to ask whether businesses that own comparable assets and are operating in the same space have been bought and sold, or whether we can impute a value from investment data where private investors decide a company with similar IP is worth a certain amount of money. Or sometimes we can just look at how much other firms are paying to license in those assets and work out what the equivalent would mean for you or for somebody that you're thinking of licensing to. So market comparison, obviously it's a great thing to do when you can, but the caveat on it is the thing that makes IP special and valuable is usually what makes it different from other people's rather than what makes it the same. So any market comparison is generally a guide rather than anything more precise. And for that reason, as we've said in the previous sessions, income is generally where one tends to look, which is to think about what's the contribution that these assets make to current or future sales or profits. It can also be, what are the cost savings that are attributed to these assets? It doesn't necessarily have to generate additional incremental income. It could just make a business more profitable by making it more efficient. And there are a number of different ways that are used to isolate intangible asset value from the value being created by the other assets of the business. One of those, which I'll show you an illustration of in a moment, is relief from royalty, because the research we've done for the Intellectual Property Office confirms that's the most popular and commonly used method. You can also think about excess earnings, which is how much more are you earning as a result of having the IP, or how far are those profits bigger than other people's because of the IP that you have. Similar but slightly different concepts. I think the first thing to do is to think about which of these methods are most likely to be useful and applicable when we're talking about the collaborative context. So here are a few thoughts on that. The first point is in the title, which is the most important one of all. In a collaborative context, it's probably easier than in a direct, full-on competitive situation to get some kind of broad agreement on what the opportunity looks like that everybody's working towards to achieve. And having broad agreement on at least the size of the opportunity and where it's located really helps, especially in terms of using income methods, which is probably where you're going to end up. Certainly in terms of all of the forward-looking or fundraising type valuations, they will tend to be done on the basis of income. But let's not dismiss the other methods just yet. So in terms of cost, it can be quite useful to show incontrovertibly, if you like, that there is value in the contribution that you are making in your background IP and in the work that you're doing on an ongoing basis as part of the collaboration. And cost is not a bad way of thinking about software specifically, or even the cost of human time that's been invested in bringing your background IP to a certain point. And that's because, given sufficient time and effort, software is broadly reproducible, and other people can get their heads around the value of a contribution if they can see it expressed in terms of employee cost. So it's kind of a difficult one to argue with unless you're talking to people whose costs in those respects would clearly not be at all the same. However, it's rather less useful if you're contributing patents to an arrangement like this. The reason for that is maybe slightly subtle. We are talking about a concept that says, what would it cost to reproduce or to replace the particular approach that you have going now? If you have patent protection in place, it's probably not legally permissible to reproduce what you've got, and it may be very difficult to engineer around it and replace it in other ways, because there may be other downsides you may have come up with for the time being anyway, the best way of doing something. So you have to be careful when using the cost method, if ever there are patents present, because you actually paradoxically risk not valuing the very thing that you think has got most value because you don't value the monopoly of it. You kind of are assuming that other people can use it when they can't. Not wishing to labour that point, but it is quite important. Also, another thought, if you're engaged in a collaborative project where there is a grant funder in place, then that funding will itself pardon me, add to the total sum that you've invested in R&D and in developing the foreground IP. So there's another cost-based relationship there that's worthwhile tracking and thinking about. Moving on to market, the area you're most likely to look at from a market perspective is licensing data. And that's because thinking about how to negotiate future revenue shares, for example, it's pretty helpful to understand what other people have paid and be able to point to factual precedents in the market for those royalty rates. Pardon me. It's also extremely useful to keep an eye out and understand whether other collaborators that you're working with on a project, particularly, let's say, large multinational organizations, if they're involved, or even fast-growing, more acquisitive companies, are actually buying and selling other businesses or technologies in the area of interest, because it gives you an idea of what their commercial appetite might be. So that's a kind of market research that's well worth thinking about. You won't always find the values of any acquisitions disclosed, but if you do, obviously that's even more valuable information. Probably where you're going to end up, though, is in the third category, which is income. this is always a pretty relevant thing to think about, because all of the parties, including actually the funding partners, are mainly interested in thinking about what this collaboration is going to produce. So by definition, it's forward-looking. Cost and market are always, to some extent, backward-looking. Cost is how much have you historically spent, or how much has somebody else historically spent. Market tends to be looking for evidence of transactions that have already happened. Income is thinking much more specifically about what you will be doing in the future and your collaborators with the specific IP and other intangibles that you've identified. And knowing what the net present value of those opportunities are is a pretty helpful thing in order to be able to negotiate a license and potentially upfront payments in an appropriate manner and a fair manner for all parties involved. If you do end up having to transfer assets from one place to another, then the OECD's rules on these things actually require income methods to be used as the default as well in most cases, because they're interested in preventing anybody from avoiding a tax liability that will arise from creating a future benefit. So hopefully that's helpful in terms of thinking about which methods are useful. I just want to spend a moment or two focusing on a couple of methods and then we'll wrap up. So the first one, I talked a moment ago about relief from royalty. Sounds like a funny term. What it means is that you are working out the benefit of not having to pay a royalty on IP that you already own. This is applicable regardless of whether or not you're actually planning on licensing the IP to anybody at all. The point of it is that it's a good way of isolating the value in the intangible assets in the IP, because those are the things that are normally licensed. You seldom license access to physical assets. So it's just a good way of thinking about separating out what the IP value is. And the calculation might look a bit like this. This is just to give you a kind of general idea of how it works. You know what some of the inputs are because you know from research typically what other people are paying for a royalty, which you might have to flex up and down a bit. You know how much tax you're going to have to pay. These things are essentially profits, so they always have to be calculated net of tax. And if you can predict with some degree of certainty, or more importantly, consensus, what the size of the revenues associated with products and services that are going to be based on the intellectual property that you're creating into the future, then you can apply the royalty rate to it. You can take off tax, and then you can convert that using a method called discounted cash flow calculation into a value today. So in this particular instance, you'll see we've ended up with a value of around 1.3 million. Now, the variable inputs that you have to consider on this, which are things that our tool and our moderation service helps do for you, is what's the revenue curve actually going to be? You can't necessarily assume that IP is going to run happily along and continue growing year on year for every year of the legal life of the protection. A commercial lifespan is normally shorter. And after a period of time, the chances are it'll start to become obsolete, and so the revenues properly attributable to it are going to start tailing off. Perhaps the critical one is this thing called discount rate, which is hiding at the top of that little spreadsheet. That really is not just a cost of money calculation, that is how much risk and uncertainty is there in the forecasts and how far does that discount factor have to be weighted in order to take account of them. Bearing in mind you're probably trying to value something that's not in market yet. These are all things that the tools can help you do. In fact, they do it for you. So that's one route. That's just showing you formally how you might get to an end number, excuse me. I just want to show you this as well. And I think, Alison, if we click through and bring the whole thing up, it's going to be more efficient. This is probabilistic modeling. It's quite helpful, particularly when you start thinking about whether there are binary risks in the proposition that you're looking at. And I've used a sort of drug implementation example because it has a number of these kind of binary checkpoints, if you like. But the principle you can apply to all sorts of different types of IP, and in our bespoke work, we often do this. So if you imagine you've got a drug, it hasn't got a patent granted yet, and you don't know for sure how efficacious it is at being able to cross an important thing called the blood-brain barrier. And whether or not it crosses that depends whether or not it can be used as a therapeutic, as a treatment, or whether it's just a marker, whether it's effectively a diagnostic. And there are different income streams associated with that. So that's a really complex picture. How do you help sort out your thinking about a complex picture where there are binary pass-fail issues? The answer is you can use a decision tree or probability tree like this, and you can start to attach probabilities to different outcomes. So what you can see from this is if everything goes perfectly, there's a 33% chance in our model that a patent will actually grant, and therefore there will be something protectable and of value. There's then a 67% chance that it will cross the blood-brain barrier, and there's a 75% chance that it can actually then be successfully made and tested at scale. These are all assessments that you can make for yourself when you're thinking about the individual risks and formulate a view on. If that all happens, you've got relatively big sales. That's not the only possible way of recouping value from it, however, because it's also possible that the patent may grant, but the therapeutic application is not possible because the blood-brain barrier isn't crossed. So you're looking at a diagnostic there. There'd still be a 75% chance that the diagnostic could be produced and made and tested. So that would be smaller, less interesting sales, but it would still be sales. But if there are no sales, as in the red boxes, or if the patent fails to grant, so there's no possibility of any protection, obviously those represent routes where there is no route to value off the bottom of it. And this is one of the reasons why everybody knows that drug discovery and pharmaceutical is quite a risky business, because quite a lot of it doesn't work. So in this simple example, what you do is you multiply up the probabilities associated with each of the individual routes, and you come up with the percentages that are shown at the bottom here. We will be circulating these slides, and there'll be a recording of this that you can use to look at it in a bit more detail if you wish. Okay, so just wanted to introduce that concept to you because I think it's actually very helpful in working through how to think about the probability of something happening, the chances of something happening, and to sort of start translating that into a financial value. Because if you know what the green circles on the right-hand side are likely to be worth, you can work your way back to a present-day position. Briefly, a couple of examples of where this has been done. I won't dwell on them. So, and these are ones that we've been involved in at Ingot. There's one particular example that comes to mind of a university that discovered and developed an antibody which would be capable of treating a number of different diseases, and got into a collaboration with a US drug company. This is a fairly common way of trying to bring things to market. Of course, you need a collaboration with somebody that's got the resources, the distribution channels to be able to actually productize, if you like, something like this. They got involved in a collaborative research program, as a result of which further patents were filed. These were filed by the drug company, but they had a license granted to the university's IP. There comes a point where the collaborator, which is the large US drug company, wants to buy, and the university wants to sell the existing stake it has in the technology that it originated. And that's one of the cases where you would require evaluation for negotiation purposes. So that's effectively getting after the end of a collaboration, probably having discussions about it during the collaboration, in fairness, to say, actually, ultimately, this IP should be in a different place. And that's an obvious reason why you need to have a valuation. Otherwise, how can you reach a fair agreement on it? That's one brief example. The second one is in glass recycling, slightly different kind of thing. A method of recycling glass was developed. Lots of interest from different recycling companies in either collaborating with the inventor or gaining access to the IP. And so under those circumstances, we help with evaluation to think about how can you get the best possible deal with the commercial entities, which might be one entity on an exclusive basis or multiple entities on a non-exclusive basis, to be able to use the technology. Okay, that's the end of our session. I'm just going to close with a little reminder about what Andy was talking about before. The free IP valuation offer, what does it mean? It means access to Ingot's tools, which helped you to, first of all, identify all of your intellectual property and then derive an indicative valuation from it, which uses both income methods and cost methods. Specifically, it uses the relief from royalty method to do an income calculation. And the advantage of that is it tells you what the kind of licensing rates are as a broad range that are prevalent within your industry. And Andy can talk you through how to get hold of it. Andy, over to you.
Thank you very much, Martin. Thank you very much, Alison, and a very warm virtual applause from everybody on the webinar. That was very informative, and thank you very much for that. We're going to go into a Q&A session now, and I'm going to look at what Q&As are there. I've got a couple myself as well, but I'll let everyone else get in there first. The one that we've got up at the moment is from Alex Dennis, and he was just asking if you could explain what you meant by the blood-brain barrier just a little bit more, Martin.
Or do you want me to take that one on, Martin?
Yeah.
Or Ian, we've got a whole team here, yeah.
I think that's one for you, Alison.
Yeah, I mean, just in short, Alex, thanks for the question. It was obviously an example just to give you an idea of the probability modelling, and really in this case, you know, it's going to be, it's drug discovery, and our bodies are very clever that there is what's known as a blood-brain barrier. So it means that toxins and things like that don't get through our bloodstream and into our brain. So it's actually very hard to get sort of, you know, typical drugs into sort of the brain. Shall we say, so it's got to be sort of small molecules, and maybe there's different delivery methods. So really for this one, it's just to show company coming up with a new drug that was had to be targeted ideally to the brain for, you know, a particular purpose. But if they came up against problems, as happens in sort of like going through clinical trials, and it's not actually doing what they expect it to do, then you'll see how it would then affect the valuation, because things aren't working. However, in the case, it might be that the molecule can actually be, or that the research that they've been using and doing can actually be used to actually help with the diagnosis of a particular condition. So the drug would be to treat a condition, and maybe what they've got, it could be, you know, some sort of gene sequence or sort of biologic or something can actually be used to diagnose a particular condition as well. So there's the potential for two routes to market, but obviously ideally the drug would have been the one that would make the most money for them if it goes through clinical trials. So you go, hopefully that kind of is a very basic introduction.
Effectively it was to treat neurological type disorders. So that's why it had to have an effect on the brain. So that's why the barrier was particularly important in that case.
That's great. I've got one for you guys, which is to do with, you were saying around when you've got your collaboration together, is that trying to work out what your contribution was to the collaboration. And I was just wondering, in your experience, if when you get people collaborating, and particularly around the income that collaboration is going to generate, do you find that people just go for the slightly easy option of, we'll just, if there's two collaborators, it'll be 50-50. If there's three, we'll do 33-33. Or do you find that companies really do try and work out what their contribution was and how that's going to equate into revenue?
So I'll start that one and then pass over to Alison. So I don't think it's usually a straightforward 50-50 split, partly because in any collaboration, you tend to get one of two things happening. Either it's very clear from the outset that there's one party that's best placed to take the resultant technology through to market, because the collaborative project is to do something very specific that everybody's agreed on. Or sometimes you're developing something that actually a number of the partners could use, but potentially in different ways. The first of those is kind of an easier situation to deal with, because then it's a question of assessing what the contribution is that different people have made and what kind of inter-party licensing is needed. The second possibility, actually, there could be lots of different licensing arrangements that are required for different purposes with kind of different shares next to them. So I think this is one of the reasons why Alison was stressing the point that it's quite helpful to get some kind of agreement on these core things at a very early stage in the project. So you've got a bit of time to work it out, and also so that you can be asking yourself these questions as the collaboration progresses. But Alison, you may want to add to that.
Yeah, I think it's just, you know, from experience, it really is a case-by-case basis, and it depends on the nature of the collaboration, possibly even the type of grant that you're going for. As Martin's correctly indicated, there's going to be different partners. So there could be an academic that's bringing a number of years of research to the table, but they don't have the ability to actually get that the outcome of the research to market. So there could be the technical side, and that's actually probably a bit easier to show a value against it in terms of amount of time it's taken, and, you know, the resources it's taken, and obviously using methodologies that Martin set out. But it really does depend on the collaboration, if it's more of technical nature or otherwise, I guess. So as it really is one to be thrashed out as early as possible.
That's great. And I'd love to, Holger, I can see the questions coming in. I'd love to ask you a question to do with that, the people valuing the research versus people valuing the exploitation, actually getting to market, part of that, which I think is something we could discuss for quite a while, Alison. Just going to the questions that are coming in. The first one we had was from Ruth Welters. Hi, Ruth, which was, how do you know in the future that you got the IP valuation right at the time?
Haha, what a great question, Ruth. Thank you. Well, do you know? I think what you know is you mainly know if you didn't get it right, which is that you didn't secure a deal that enabled you to get a fair return on the investment that you'd made in the collaboration. But I guess this is one of the reasons why licensing is such a popular way forward, both for academia and for individual companies. If you can agree on a fair royalty rate, a licensing rate, for the commercialization of the outputs of a collaboration, if you're not going to do it yourself, then you know that you are going to get a slice of however successful it is, which is sometimes a more palatable thing than having sold it for what you subsequently come to think is an undervalue. So licensing has a fair bit to commend it there. It can also work the other way around, of course, which is that if you're the party that is taking something to market, you want to be sure that you have the rights that you need to be able to take it to market without dispute, and it's natural you have to pay something for that, but you're paying a royalty rather than having something that is a fixed cost, a large fixed cost, independently of how successful you are or aren't. I think where there is quite a bit of debate sometimes is around where should the minimums be set. We talked about that a bit last week in terms of licensing, but it is relevant here too. If you want to motivate somebody to really press ahead and commercialize the technology, then it's quite nice for them to be incentivized by knowing that there is some minimum cost that they have to pay as a result of using your technology. And that's where the negotiation comes in, because naturally, if you're on the other end of that discussion, you're going to want the minimums to be low so that it hedges your risk.
And kind of linked into that a little bit, anonymous questions come through around, is there an approximation that can be made on the increased value of your business if a patent is successfully granted?
Sort of. So sorry not to give you a more direct answer, but I think the answer lies in the probabilistic chart that I showed you earlier. What you've done by getting a patent successfully granted is effectively you've taken one more risk out of the chain. So you know as a result of the patent that you should have something that is enforceable. Obviously, it's a bit more complicated than that because it depends on who you're up against and what rights they have also. But in general terms, yes, it is an inflection point with value, but it depends also on who you're presenting that value to. If you are presenting it to investors, for example, they'll take some comfort in it, but they'll be probably more interested in what your commercialization route as a whole is, how you're going to start generating value and income than in the protection per se.
That's great. Thank you for that, Martin. We're running slightly over time, but I would like to just ask this final question before we go to the summing up, which was from Adam Powell. It is a good one, I think, which is around international collaborations. And can you give any advice on the best approach in navigating international IP law when a small UK creative company is developing foreground IP, working collaboratively with a US multinational?
Yeah, I think probably the best answer for that is to get yourself, if you're on the technical side, a good patent attorney in the UK, probably, because they'll work with their associates in the US to obviously take you through US law. Now, you say you're a creative company, so I don't know if you might be more sort of copyright assets and you know, less on, you know, patented technology, but, you know, copyright is also an unusual one in the US, that you can actually register your copyright. They've got a copyright registry. I think just anything to do with working with a multinational, they will try and obviously get you to engage and use, you know, sign up to various long-winded contracts, NDAs, things like that. So, as I say, it would be well worth speaking to a UK patent or trademark attorney on this, and they can advise you, because the US law is one of the sort of quirky ones. So on patents, you know, you need to be aware of different types of rights as well, because they have some other quirky sort of patent prosecution matters too. In terms of actually getting protection, thinking about US patent protection, for example, as well might be something to consider, but you obviously need to budget for that. But it might be the multinational would pick up the patent costs, but you would need to negotiate your access rights and things like that going forward. So definitely sort of legal advice, a chartered patent attorney, trademark attorney. There might also be, if it's maybe through a grant body, they could have some help desks that you can ask as well, and certainly also through the Enterprise Europe Network team, because although it's the Enterprise Europe Network, you know, they do have colleagues in the US as well. So there's also going to be assistance if budget's a little bit tight. So always worthwhile asking for help if you can.